about the date the legal notice was issued, which coincidentally is the same date that the letters for the respective commissioners were also issued. And I would ask the Secretariat to provide the witness with the MOJ 3 series, that is MOJ 3A, B, C, and D. Are the documents before you, Mr. Tambadou?
Yes, they are.
Should I allow you a second to go through them, or you're fine? Great. Let's begin with MOJ 3D. Which was the appointment of the chair. The current doyen of the bar. It's dated the 12th of July 2017, and it is signed by the Solicitor General at the time. Great. So it is clear that the commissioners were headhunted, which, as you have explained, was a mechanism put in place by yourself to ensure that you got what the Ministry of Justice, acting on behalf of the government, wanted in a commission and in a chairperson. A letter was issued to him, and the letter is marked MOJ 3D. Now, this part would have to be tedious because I wish for us to go through each of these letters and read them. If you could do me the honors of reading the letter. Perhaps if you could just highlight the date, the addressee, who it's coming from, the heading, and then the content.
The letter marked MOJ 3 is dated 12th of July 2017. It's addressed to Suahata B.S. Janneh, and it's headed Appointment as Commissioner in Commission of Inquiry. It is signed by the Solicitor General and Legal Secretary, and the letter reads, I am pleased to inform you that the President of the Republic of the Gambia, His Excellency Abubacarr, acting under Section 200, subsection 1 of the 1997 Constitution of the Gambia, has appointed you as a commissioner in the Commission of Inquiry into the financial activities of public bodies, enterprises, and offices as regards their dealings with former President Yahya A.J.J. Jammeh. You're further designated as the chairperson of the commission. Kindly familiarize yourself with the commission's terms of reference as a guide to your work. Congratulations and best wishes in your new appointment.
Now, our mandate as a committee is to look at the assets identified, sold, disposed of by the Janneh Commission. While that is our primary mandate, it is essential for us to look at the manner in which the Commission itself was set up. To look at its administration, at least from a bird's eye view, not to go too deep into it. The question I have here is, in the third paragraph, there is reference to a terms of reference. Can you guide the committee as to which document is being referred to on the third paragraph, in the third paragraph?
Based on my reading of it, this must be referring to the legal notice that established the commission, because it's the legal notice that includes the terms of reference for the commission.
So when we speak of terms of reference, are we talking about the legal notice, or is there a separate document?
The legal notice includes the terms of reference of the commission.
Of the commission, right. Okay. Otherwise, we could call it the mandate of the commission.
Yes.
And that would be the terms of reference of the commission as a whole.
Yes.
Right, as a unit.
Yes.
Right. My qualm, or rather the committee's qualm, from the appointment is not in the manner in appointment, because you have stated the reasons why. But once appointed, the chairperson was not given a specific terms of reference from which to deduce the level of his authority, from which to deduce how he should operate within the commission. Would you like to comment on that?
Well, typically, the Commission of Inquiry, which was established under Section 200, will be guided by the provisions of that section, first and foremost. And then, of course, the provisions of the Commission of Inquiry Act, which contains supplemental provisions on how the commission should function. And in addition to that, the terms of reference, which is contained in the legal notice, provides the parameters within which the commission should operate as to how the commission effectively exercises how it functions effectively. That would be up to the commission to determine. In fact, it's part of granting the commission independence to determine its operational parameters.
Yes, I agree that as a whole, as a unit, it would guide them, and it would be better for the government to allow them to, allow the commission rather to set the parameters as to how they would work. My question relates to the chair in particular, and whether he was given a terms of reference specific to him as chairperson of the commission.
Neither the chair nor the other commissioners were giving a specific terms of reference outside the legal notice or the Constitution or the Commission of Inquiry Act.
All right. In the instance of the chair, perhaps I can agree. And of course, the chair is the doyen of the bar. We would usually or normally perceive that he would be able to deduce the provisions of Section 200 and the Commission of Inquiry Act to figure out his role. However, as is the practice in public service, each servant is afforded a tailored TOR specific to them as to how and what they are expected to do to go about their work. And while there's no reference to a specific terms of reference in the chair's letter, I would invite you to look at MOJ 3A. The content is largely the same, but I would ask you to indulge me to read the third paragraph once more.
It's addressed to Abubacarr George, of course. Same date, 12th of July 2017. Appointment as Commissioner to Commission of Inquiry is the heading. And the third paragraph reads, kindly familiarize yourself with the Commission's terms of reference attached herewith and your attached TOR, meaning terms of reference, as a guide to your work.
So you agree with me that there was a specific TOR for the specific commissions, at least for the commissioner that goes by the name Ms. Abubacarr George?
I wouldn't say there was a separate TOR. I would consider this as an error in the drafting of the letter. It makes reference to two TORs. The only one that exists is the one that was contained in the legal notice.
Yes, but once more, I would contend and say that, in fact, this letter is drafted in standard public service format to entail a specific TOR, because every public servant needs to be guided on their specific function, their mandate. Now, while the TOR for the commission is the mandate of the commission, because the mandate of the commission would not actually be found in the law. The authority of the commission, rather, would be found in the law. The mandate of the commission will be found in the legal notice. And that is what I perceive as the TOR for the commission, which I would more appropriately use the word mandate, because it's more appropriate for an institution. The mandate of the institution was the legal notice. Now, the letter makes reference to a TOR for the specific commissioner. However, this letter, and the letter is copied to you, of course, from your head of admin. However, there is no document attached to it to spell out the functions and the role of the commissioner.
Yeah, and that's why I said I believe that third paragraph, the reference to a second TOR, is an error, and the only terms of reference which you call a mandate, it's also a mandate, is what is contained in the legal notice. Now, as to how the commissioners function, that would be up to them to determine. I'm not sure if I get the crux of your question, but it's similar to a judge of the High Court. They are guided in their work by the rules of court and procedure, etc. In the case of the Commission of Inquiry into the Janneh Commission, we left it up to the Commission to determine its own rules of procedure and evidence, as we did for the other commissions like the TRRC and the CRC.
Yes. Their rules of procedure, I would agree with you, it would be much more appropriate to allow them to develop that. It would show a mark of autonomy. However, the specific TOR does not relate to rules or how the commission operates. The TOR is meant to guide the servant, the public servant, in his or her daily function. Now, if from your testimony, I'm deducing that you did not see a TOR fit. You do not see it being a necessary addition.
Well, yes, there was no need for an additional TOR over and above what was contained in the legal notice.
Would you expound on that?
Well, what I mean is the legal notice is very clear as to what the Commission is expected to establish as a matter of fact. Now, it was up to the Commission to determine how best to achieve that. That would be my reading of the situation.
And the distinction between the role of the chairperson and the other commissioners, who would draw that? Would it be appropriate for the commission to draw that?
Well, why not? It's a three-person commission. I am assuming the reason why, not assuming, the reason why we had three was because we expect in general the commission to arrive at decisions by consensus. And if there is no consensus and it's put to a vote, that's why we have the odd number, so that it will be by majority.
Yes, my qualm again is not about decisions. It's just about guiding the individual on their day-to-day work.
But counsel, maybe I'm not understanding your question, because that was left, it's up to the commissioners to decide how they wanted to do that.
Yes, but Mr. Tambadou rather.
I'm glad, Tambadou, yes.
Tambadou, yes. It's the government who established this commission. It is the government who gave it its authority, its mandate, what we are referring to as the TOR of the commission. Because this is the aim of the government. Cabinet sat down and conceived an idea and said, this is what we want. Don't you think it is prudent for Cabinet to go a step further, as alluded in their appointment letters, to provide a concise TOR? Now, I enjoy your examples, because you make the example of the judge, of a judge, and I will ride along your example and say, a judge of the High Court, when appointed, perhaps the Chief Justice would issue them their letters and say, I am sending you to the criminal division, I am sending you to the civil division, or I'm sending you to the commercial division. They know that they're going to sit over commercial cases, right? They know the general mandate of the judiciary, but they themselves have a terms of reference. It's important because the terms of reference keeps the public servant, it's a tool for accountability. You outline what roles the public servant is supposed to carry out, and that's the point of reference. Otherwise, we have no point of reference except for the mandate of the commission, which is a collective mandate. Now, perhaps you can help the committee deduce from the legal notice, which is MOJ 2, to figure out how the commissioners would go about deducing their individual responsibility. Please guide us. In the absence of their individual TORs.
Your reference to public servants is helpful, but does not necessarily apply mutatis mutandis to this scenario. The public servants are governed by general orders, etc. So there is a standard set of rules that apply to public servants. In the case of the commission, that has the powers of a high court judge in certain respects, particularly procedural matters. I think the commission, I am at a loss as to what you're driving at, because
let me put it this way.
The terms of reference are clear. They have a task at hand. They can determine their own rules of procedure and evidence in terms of what rules to apply, what rules not to apply.
That is not in dispute.
Yes, so I don't understand. What else are you looking for in terms of the functions of the commission?
Let me put it this way. We have it on good authority from our investigation team that in the case of other commissions, the roles of individuals were clearly spelled out in subsequent commissions.
In commissions in this country?
Yes.
Okay.
The roles of individuals were clearly spelled out.
And the roles of the commissioners themselves?
Yes.
Really? I would like to see that.
Well, it is authority. Just like your reports from different institutions, I would have to say that this report is also a verbal report. unfortunately.
Ah,
You see
so
how difficult it is to...
No, but you're talking about written terms of reference.
Yes.
So I would like to see something like that.
All right. In the absence of the physical document, because it is not available for you now, what would be your comment if I were to put that to you, that in other commissions, the roles were clearly spelled out? The role of the commissioners, the lead
Spelled
counsel,
out by who?
by the government.
By the government. So you would agree with me then that in this case, compared to those commissions, we allowed more independence in this commission than in those ones because we did not prescribe how they should function.
Well, I would disagree with you because it is not, providing a TOR is not dictating how they function. It is outlining what is expected of them. Now, how they function to reach, to carry that out is up to them. I would agree with you.
We did
And I would also disagree that it gave them independence. I would say that it clouded, it muddied the lines. There were blurred lines as to who is to do what and who is responsible for what.
I don't think the commissioners or counsel or I sitting here will agree with it at all. I think the distinctions were very clear as to what was expected of counsel, whose role was to assist the commission, and the commissioners who presided over the hearings and proceedings of the commission. I think those roles are very, very clear.
You will stand by that submission then?
Absolutely.
Okay. Let's proceed to the last commissioner. That should be MOJ 3C. A similar provision is there, and that is Mr. Baimasen. He was also headhunted.
Yes.
Now, how did you come to be acquainted with Mr. Baimasen?
Oh, I knew Baimasen personally before he was made commissioner.
He was a friend.
Yes, you can call him a friend.
Yes, and you trusted in his professional abilities. That's why you headhunted him.
Absolutely.
Great. Let's move on to the secretary. Who is responsible to appoint the secretary?
In this case, it will be the president, based on the legal notice, I believe.
And the law? And
Yes.
the constitution as well?
I'm not sure if it's in the constitution, but perhaps the commission of inquiry.
Commission of inquiry.
Yes.
Okay. So the law and the legal notice are in tandem, that it is the president who appoints the secretary.
Yes.
Did you as well advise the president on the appointment of the first secretary, Mr. Alhaji Mahmoudi Quran?
Certainly, I recommended his appointment to the president.
All right. Let's stick to Mr. Quran. Was a TOR provided for Mr. Quran?
Not to my recollection, but the idea was for the commission to provide Mr. Kurang with his terms of reference and his responsibilities.
Was this idea communicated to the commission?
It did not need to be communicated to a commission. The commissioners are in charge of their proceedings. They would be responsible for the different activities and functions of the different units, including counsel and her team, and of course the Secretarial.
So if I'm understanding your testimony, the government set up a commission, gave it a mandate, and allowed for the commission to develop its own TOR. Now, I see a double standard in the submission, because in one breath, the submission is that the commissioners and anybody else can deduce their terms of reference from the collective mandate. On the other hand, the submission is that it is for the commission to develop the TOR. Now, which one is it?
I'm not sure there is a double standard there, counsel. The terms of reference of the commission, which you call a mandate, the mandate of the commission, is included in the legal notice, and the responsibility, and the objectives are clearly spelled out. How best to achieve that objective will be up to the commission to determine. what we did was to provide a secretary who shall be under the authority of the commissioners, and of course counsel and her team who will assist the commissioners. And I think the delineations of those responsibilities are clear for the commission. It was for the commission to develop that further. What we did was to allow them the independence to do so in a manner that they thought was fit for them.
Okay. Now, Mr. Tambadou, I would want us to apply our mind here. This exercise is not only a fact-finding exercise, but the results from this exercise would advise future endeavors. Now, from your testimony, it seems you have great compassion for the country. And I would want to tap into that compassion and ask, if you were to redo it again, you did mention that you would stick with the same team. You were quite confident in the team. If you were to do it again, would you allow the lines to be blurred as they were, or would you define their roles?
Well, first, I think the first point of divergence is that I don't think there was any line that was blurred. As far as I'm concerned, we allowed the commission to, as I said, develop its own internal working protocols or guidelines, if you like. I'm not sure I can call them terms of reference, but perhaps they are protocols or guidelines that they could rely on, and we allowed them that independence because we didn't want to be prescriptive, if you like. And two, if I were to do some of these things again, I have said over and over and over, self-reflection is part of growth, and there's always room for improvement. There's always things that you could do differently at various points if you had different sets of circumstances. So my answer to you would be, if I had to do things again, certainly I would have learned lessons from how we did it in the past and improve upon any new process we were going to put in place.
Okay, we will come back to that shortly. Back to Alhaji Mamadi Quran. It was your recommendation, of course.
Absolutely.
Another individual that you are well acquainted with.
Another individual that I knew.
Okay.
I wouldn't call him a friend, but I knew him.
All right. And how did you come to know Mr. Quran?
I've known Mr. Quran for a long time. He was my head boy at St. Augustine's High School.
I see. To the best of your knowledge, had Mr. Quran ever worked in the public service prior to his appointment as a secretary?
I don't know, or I can't recall, but our focus in getting Mr. Quran was to identify someone in the private sector who had knowledge in accounting, background, etc., whose skills we thought the commission, such a financial commission inquiry could make use of. So we identified him, and I recommended him on that basis.
In what capacity was he supposed to exemplify his accounting skills?
That would be under the guidance of the commission. It will be for the commission. We just provided the tools for the commission to make use of. And the tools here is someone who has a background in accounting, in finance, etc. And Alaji fitted that bill for us.
I agree with you. He has an excellent background in accounting.
You wouldn't be head boy in St. Augustine's in my days if you weren't bright.
I would agree with you, but again, it's another thing that perhaps will escape me because I wasn't there those days. But I would want to ask whether you were aware that Mr. Quran had the skills of a secretary or the expertise of a secretary.
I am hesitating to answer your question because what would constitute the skills of a secretary? You see,
I like that question because it tempts me to go back to a TOR, because the TOR would clearly spell what would entail and what would be the skills of a secretary.
Yeah, but you see, that's you're focusing only on written TOR. In this case, the secretary would be under the guidance of the commissioners, particularly the chair, and his role would be to execute the directives or orders or instructions or requests of the commissioners. And
however, don't you think secretaries also have an advisory role? It's not just to take instructions.
In this case, no. My idea of a secretary in a commission is equal to perhaps the registrar in court. The registrar in court is there to execute the orders or instructions of the court to ensure that the court's orders are complied with, and to carry out other administrative assignments that the court may from time to time order. Registrars don't have any advisory roles for the court, as far as I know. And so I would describe the role of a secretary to a commission of inquiry in that manner as well.
So you don't agree that a secretary has an advisory capacity to their work?
In a commission of inquiry?
Yes.
No.
Okay. I would again contend with you. I do believe that the secretary always has that prerogative, at least to advise. And
if you equate that to the role of the registrar in a high court, would you say the registrar in a high court has an advisory role?
in fact, I would equate it to the role of the judicial secretary. That would be a more appropriate comparison. Or the role of the clerk of the National Assembly.
No, counsel, it's different. The role of the judicial secretary is constitutional, and in fact, it was an invention after the 1997 Constitution was adopted. Before that, there was no judicial secretary, if you like. But in any event, we have differences of opinion in terms of the role of a secretary. In my view, it's more akin to the role of a registrar in court and not the judicial secretary at all. The judicial secretary has additional responsibilities that the registrars in court do not have. And to impute that the secretary to a commission of inquiry shares those same responsibilities is to, I believe, broaden the scope of a mandate of a secretary to the commission.
So then what was the need of his accounting background if he is not to advise on any accounting? He is just to take instructions.
Well, it would be up to the commissioners to make use of that background if they see fit. They could consult the secretary if they saw fit, but to arrogate to the secretary the if you like, mandate to advise, then that's another thing. You are empowering the secretary to provide advice, and I believe that is not the point of the commission. His background certainly would be relevant if the commissioners wanted to rely on it. It's a tool again at their disposal. Because once you give the secretary more powers, then you're almost putting him almost at par with the commissioners, and that wouldn't be the role of the secretary.
Again, I would contend with that. I would not think that giving him advisory powers or any similar such powers would equate him to the commissioners. He does not make decisions. It simply puts forward his proposals to the commissioners for their consideration.
I don't think even without those powers he was stopped. He could be stopped from doing that. He could always offer his views to the commission.
Precisely.
There was nothing that I think would stop him from doing that. But once you formalize that into an advisory role, then you give it a little bit more weight, and that's the fear that I am that I am concerned about.
Yes, but you just stated that it was inherent anyway for him to offer a word or two.
If
At the discretion of the commissioners, of course. It's not sacrosanct, they have to take it. Yeah, okay. So the other component I was trying to highlight was that Mr. Alhaji Mamadi Kurang, from our records, to the best of our records, never served in the public service. This is a public body. It operates much like any other public institution. Of course, it has its own unique attributes. However, you did mention earlier today that the trend in commissions of inquiry, in this country especially, is to heavily tap from the public service. And I believe that is just logic, because it is the public servants who are au fait with the modus operandi of public offices. And they know what obtains. Now here's a person who is emanated from the private sector. And I'm not saying that's an anomaly or a bad thing, but my qualm is that Mr. Kurang had not exhibited any such skills as a secretary. In fact, I would want to think that his best position would have been an investigator of some sort, since the subject matter of the commission was matters of finance. And I'm not in any way trying to insinuate that your appointment was wrong. I'm just trying to understand the rationale. He's a finance expert, no secretarial experience, but yet he becomes the secretary to the commission. And I would think that if there was one position that would be reserved for a public servant, at least to bring some sort of institutional benchmarking from the public service, it would have been the secretary. I'm just thinking out loud.
That's why we brought in counsel, Bensouda.
And counsel was in private practice. Of course, I'm aware that counsel had served in the position you were serving, and has served in various other positions in the public service, but counsel was in private practice.
You know, the choice of counsel Bensouda was also deliberate. And it was based on all of the reasons that you just gave now for a secretary. She was in private practice. She still is. She has a very...
I would just stop you there, Mr. Tambadou. I promise you we will get to Miss Bensouda next.
Okay.
Let's finish with the secretary.
But for now, the idea was to bring in counsel who ticked all the boxes that you have identified for a secretary. In this case, the role of a secretary, as I said, was to carry out the instructions of the commission, and for the commission to rely on their expertise if necessary.
Can you just clarify that last bit? I had missed that. My apologies.
No problem. The role of the commission in this case, as I said, was to carry out the instructions or orders of the commission, to head the secretariat, the administration, and to make themselves and their expertise and experience available to the commissioners if they needed it at any time.
The last bit sounded like an advisory role to me.
But I did say that...
Are we saying that it's...
I did say that there's nothing stopping the secretary from offering his advice, and there's nothing stopping the commissioners from accepting that advice, in spite of the absence of any specific written terms of reference for them.
Okay. Let's move on to lead counsel. How was lead counsel selected?
I identified her and approached her.
You mentioned some debates.
Debates as in?
You had mentioned previously some debates before I interrupted.
Yes, no, I was saying the profile of lead counsel, why I approach her. So in addition to the criteria that I had mentioned earlier for the identification and appointment of Mr. SBS Janneh, Counsel Ami Bensouda also had all of those qualities. But in addition to that, she was a very experienced public servant. She held the position of Solicitor General for a number of years, acted, of course, as Attorney General for some time, and then went into private practice, where she continued to represent public enterprises, and then had a very, very, I believe, successful commercial law practice. So she fitted all the additional requirements that I wanted for counsel to the commission, and that's why I approached her.
All right. Just the same question again. Were you an acquaintance of Ms. Bensouda?
Professionally, yes.
So you had known each other professionally?
It's a small country. There were a few lawyers in those days. Yes. Unlike these days, you have a lot more.
Indeed. We have arrived.
It's a good thing.
Yes, it is. Indeed. I want to look through the criteria used, the lenses used to appoint lead counsel a bit more closely. And with the utmost respect to Ms. Bensouda, who I have the utmost regard for, was the criteria of conflicts of interest looked at by the ministry?
Right from the start, absolutely.
And that was consistent for all?
Absolutely,
personnel.
for all of them. The one question that I always ask is there any reason why you cannot perform this role? That's always.
And was that question posed to lead counsel?
Oh, absolutely, yep.
And what was the response?
Her response was, no, there was not, but if it ever occurred, then there was a mechanism to deal with that. There is always, you see, maybe I should elaborate further on this issue of conflict. I think there is a lot of misunderstanding about conflict. Conflict of interest depends on the individual circumstances of each case. And just because there is conflict or conflict is foreseeable doesn't mean the people affected should automatically not be given a responsibility. What occurs is when, and that's why mechanisms to manage conflicts of interest are included in a lot of arrangements. And what typically occurs is that once you realize that you may be conflicted in a certain situation, you request or you are recused from that situation, and somebody else comes in and deal with the situation and take you out of that equation. So just because there was potential for conflict doesn't mean that you will not assign someone work. If we go by that principle, nobody will be given any work in this country. This is a country of 2 million people. I mean, the professional class is so little that we all have had dealings with one another in some form. We all have personal or family relationships in a place like this. So if we go by the notion that once potential for conflict arises, the person should not be given an assignment, then I don't think anybody in this country will ever be given any assignment at all. Who knows? I may actually be related to you. Who knows? It's a small country.
I think we actually might be related. I will start calling you uncle from now on. Yes, but I do appreciate that. It is a tiny country, and perhaps that should have been a reason to keep it public. Because it's a tiny country, you don't give it to somebody that's in private practice, but you give it to somebody who is in public practice as the practice obtains.
Again, we're going to the issue of independence. We wanted total independence in this commission, to the extent that we avoided going to get people serving in public offices, because we wanted a process that was completely detached from government. Completely detached from government. And that is why we went to seek people from the private sector.
But we have established that. I would save that for a bit later. I would take your answer for now. So the question was posed rather to Ms. Bensouda, whether there could be any possibility of conflict. And the response was in the negative, but with a disclaimer that where it arises, there is cause for disclosure and perhaps subsequent recusal.
And that did occur in the course of the Janneh Commission hearing.
That's fine. We will get to that.
Okay.
However, I would like to show you a document. Honorable Chair, I am making reference to the submission by the Honorable Secretary General submission, and it's folio 151 in the submission. I would ask that the Secretariat provide the witness with folio 151. The document I'm looking for, folio 151 is a document that is stapled together. It's a series of documents stapled together, rather. You would see that I'm looking at page 5, the second document, which is the 5th page. If the Secretariat wishes, they could borrow my copy, and I could allow the witness to peruse it for a minute and retrieve it back. Should I proceed?
Yes, please, go ahead.
So Tambadou, your testimony today is that part of the criteria is to filter through any possible conflicts of interest. And this question, as a matter of practice and standard, was put to every appointee, whether appointed by the President or by the Minister of Justice. And particularly when it came to the lead counsel, the question was put, as it was put for the other personnel, and the response was the same. Now, the document before you, would you please highlight the date of the document?
It's 7th of June 2017.
And who is it emanating from?
It appears to emanate from Ami Bensouda and Co.
Is it appearing, or is it actually a fact that it is from?
I say appear because I'm putting a caveat. I don't know how to authenticate this, and it appears to be a photocopy. So I will say appear. But for all intents and purposes, let's assume it is from Ami Bensouda and Co.
Very well. And for all intents and purposes, once submitted to us in its certified copies, The official document, whether in copies or...
Well, it's a
But-
photocopy, so I don't know where it came from. You haven't given me the provenance.
Very well. Let's go by that for now. So who is it addressed to?
It's addressed to the Managing Director, Social Security and Housing Finance Corporation.
Please turn 2 pages on the same document.
2 pages down,
Yes,
at the last page.
the last page.
Yes.
And whose name is at the foot of that document? Well, not at the very foot, but who signed the document?
Who signed the document? Well, there's a signature, and the name above the signature is Ami Bensouda and Co. And under the signature says Ami Ndungu Drame Bensouda.
And who is Ami Nyungu Drame Bensouda?
I can only assume it's Ami Bensouda.
The lead counsel.
That's what the assumption will be here.
Okay. I would confirm your assumption to make
Okay.
it fact. And it's signed.
There's a signature. Yeah.
Yes. There is indeed a signature. Now,
Or
I
there
want
appears to be a signature rather. Yes.
Yes. It appears to be a signature. All right, that's fine. What's the date on the document again?
The date of the signature or the date at the heading of the...
No, the date of the...
It
the
says
letter.
7th of June, I
Yes,
think.
7th of June.
2017, yes.
When was the commission established?
It was established in July.
In July.
July 2017, yes.
And this is June 2017.
That's right.
So this precedes
Indeed.
the establishment of the commission.
Yes, indeed.
All right. Let me also ask you to look at MOJ 2, which would be in that big document on your left. Shouldn't be too far from the first page.
MOJ 2.
Yes.
Okay.
That's the legal notice.
Okay, I see the legal notice, but it's not. That's the one. Oh, it's not this one. Yes. Okay. All right. Yes.
So I want us to look at paragraph 1 again of the preamble. This time around, I just want us to highlight the institutions that are involved in paragraph 1. Perhaps the first institution, you read the first two institutions.
The Central Bank of the Gambia, Social Security and Housing Finance Corporation.
All right, let's go back to the letter. The letter is addressed to Social Security
Housing Finance
Housing
Corporation.
Finance Corporation.
Yes.
What's the heading on the letter?
Legal assistance engagement letter.
Could you please kindly, just for the benefit of my members, explain what an engagement letter is?
Well, it's the hiring of a lawyer to perform an act.
So basically, a client instructing a lawyer to take
Yes.
them on.
To perform an act, yes.
Okay, so, and of course, the RE, the RE, would denote that it's a response, wouldn't it?
Not necessarily. I have seen correspondences with an RE that are original or that initiate correspondences. RE just refers to the subject matter.
Fair enough. Let's read the first paragraph.
You want me to read the first paragraph?
Kindly.
Dear sir, many thanks for your instructions in relation to this matter.
Just a minute there. So, again, it is clear that this is a response to our earlier communication.
Well, yes, it appears to be the case. It says for your instructions in relation to this matter.
Yes.
So there must have been,
A prior communication.
yes.
You can proceed.
I write to confirm the basis on which we have agreed that Ami Bensouda and Co., in brackets AB and Co., close brackets, will act on your behalf to represent the Social Security and Housing Finance Corporation in connection to recovery of several loans and debts granted to former President Janneh and his affiliates.
All right, that's sufficient. Now, Mr. Tambadou, I wish for you to reconcile this for the record and for the high table. The memo makes reference to Social Security and Housing Finance Corporation as an institution of interest.
Mm-hmm.
And for some reason, the legal practitioners who have accepted on record to act on behalf of Social Security have been appointed as lead counsel to the commission. Wouldn't you say that is the definition of a conflict? And wouldn't you say that a conflict arose from the get-go?
Yep. I would say there was a risk of conflict if Mrs. Bensouda were to also ask counsel to the commission deal with the issue of Social Security and Housing Finance Corporation during the commission's proceedings. But that was not the case, and I will say why. When, as you know, the commission had a broad mandate, you refer to paragraph 1 of the legal notice that listed many state-owned enterprises and public corporations, including Social Security and Housing Finance Corporation. And so Ms. Bensouda was hired to assist the commission as counsel. When it was the turn to hear evidence on activities of the former president in relation to Social Security and Housing Finance Corporation, Ms. Bensouda approached me herself in my office and declared to me that a conflict of interest could arise as a result of her engagement with Social Security, and advised that I find another counsel to step in her role for the duration of the hearings about Social Security and Housing Finance Corporation, which is what was expected of her as a professional. She disclosed this potential conflict and advised that she was recusing herself, and further advised that I find a replacement, which is what I did. And that is why, if you go back to the commission's proceedings, I had hired Mr. Mustafa Bachili as counsel when the commission was dealing with matters regarding Social Security and Housing Finance Corporation.
At what point did lead counsel approach you to declare the interest?
As in?
Was it before appointment or once the commission had commenced it?
Oh no, it was during the hearings. But like I said, which was normal, she was not counsel to all these other state-owned enterprises. But once we got to a point where there was potential conflict, she disclosed that conflict. And that's the point about conflict. All you're required to do is disclose it, and then it will be up to the person who has engaged you on the assignment to decide how best to mitigate the risk of that conflict. And I think she did that here, and she recused herself actually, and I appointed Mr. Mustafa Bachili.
Yes. However, my issue is with the timing. At what point was that conflict declared?
In the course of the proceedings, but before, I believe, before the issue of Social Security was broached by the commission.
All right. Now I go back to the TOR phenomenon. You see, if this were the TOR, the legal notice were the TOR, let me concede momentarily to say that the TOR is are the terms of reference, then lead counsel would be looking at her terms of reference and see an evident conflict from the word jump, from the beginning. Do you agree? It is in the first paragraph, second sentence. A client.
Yes, she would have noticed a case of potential conflict at that point.
And when at the point of appointment, the question was put to her, did she declare that there could be a potential conflict?
Well, that's what I said. If you recall, my comment was that the question that I asked everyone was, is there any reason why you cannot perform this function? And obviously she said no. She had to consider it, by the way. It was not instant. She reverted and said no, there is no reason, but that if there was conflict, she would bring it to my attention. I do clearly recall that. In fact, to be fair to Mrs. Bensouda and to give her credit, when I first approached her as a potential candidate for judgeship in the Supreme Court, because again, we will get to that. I was doing a lot of headhunting around the time to look for people to man a lot of these positions. I approached her first to serve as a judge on the Supreme Court. It was in her office. I went to her office, just like I went to the other judges to invite them. She said to me, my commercial practice is such that it will be difficult for me to serve as a judge in this country. And so it was best for her not to accept the offer of appointment as a judge. So as early as my interactions with her, she has always been conscious or mindful of getting herself engaged in a situation that would potentially give rise to conflict. And in this particular case, I believe we should actually be applauding her for coming up and declaring this conflict and advising me to appoint another counsel in her stead.
So at this very point, I would, to a degree, agree with you. Indeed, when the conflict arose, she declared it. However, having said that, it could be argued that the conflict arose from the date of her appointment. Because a month before, she received instructions from one of the very institutions that she was about to investigate. And mind you, that institution would own about 3 of the properties, 3 of the assets that they would go on to deliberate on.
You know, counsel, if I were to go through the list of corporations here and I am looking for a lawyer who has got all the, who satisfies all the criteria that I have outlined, including experience in the public service, etc., we will struggle to find a lawyer in this country who never dealt with any of these public enterprises. And in this case, Ms. Bensouda only dealt with one, as far as I knew, and as far as she brought to my attention, amongst a list here. I think it's fair to say that when that public body was to be, when the proceedings to look into the dealings of that public body were about to start, she recused herself. And that's what you need to do in conflict. You don't have to recuse yourself from the start because, like I said, you will struggle to find counsel who would meet all of those criteria and yet never dealt with any of these bodies.
Would you struggle to find such counsel within the ministry?
It was a deliberate choice to look for counsel outside. Again, it goes back to the issue of the degree of independence that we wanted this commission to have. We didn't want the commission to have any links with the government at all. We didn't want it to be independent only. We wanted it to be seen to be independent. And besides, I was struggling with my resources at the ministry. I couldn't, again, I said earlier, I had to outsource the NIA 9 case to Mr. Gay to conduct the prosecutions because we were just overwhelmed at the ministry at that time.
Is the answer to the question that it was difficult to get somebody within the ministry?
I gave two answers. First was we wanted to make sure there was not only independence of the commission, but it was seen to be independent. We didn't want government. We didn't want it to be linked to the government in any way, except of course for the money, because the government has to provide the money.
And of course the reporting lines.
Well, there were no reporting lines.
No.
I don't know what you mean by reporting lines.
At the conclusion of the commission, they are bound to report.
It's a presidential commission of inquiry. It's the president who set up the commission.
Indeed.
They have to submit their report to the president.
Indeed.
But that's the extent of the link.
But you cannot delink them from the
Well,
government. In
yeah,
fact, one would argue that they are part of the executive.
Not at all. Far from it. They are an independent commission of inquiry. That's the letter and the spirit of Section 200 Council. Otherwise, why set up a commission of inquiry? Otherwise, why have the provision in the Constitution for the president to set up a commission? I mean, it's to ensure that there is independent fact-finding exercise and to advise the president and make recommendations on what actions to take to prevent recurrence.
So how come the lead counsel then came to you directly instead of going to the independent commissioners?
I was the one who appointed the lead counsel.
But
She was appointed by the attorney.
Once you appointed her, there were no reporting lines.
Oh,
She
no,
was answerable perhaps only to the commission.
Okay, let's put it this way. You think if she went to the commissioners, I don't know even if she did, she might have informed the commissioners. I wouldn't put it past her, knowing her level of professionalism. But let's assume she went to the commissioners to tell them. Are the commissioners going to appoint another counsel to replace her? It was not for the commissioners. It was for me as the appointing authority. So she had to come to me to tell me so that I could replace somebody. I could replace her with somebody else.
Precisely. You cannot delink the government.
No, you said reporting lines. Because when you say reporting lines, it denotes an obligation to be reporting to whoever it is about your work.
I believe I mentioned reporting. Not
Okay.
reporting lines. And,
Okay.
I also clarified that at the end of their mandate, they would report to the president. And
Well,
I
they would
believe you confirmed that it was a presidential.
They would submit their report to the president.
Yes.
Yes, but there was no obligation to report to anybody. We wanted them to be independent. They acted independently.
All right. So I see in one instance, the lead counsel would approach you directly. In another instance, TOR, it's left to the commission.
Well, yes, counsel. Naturally, I don't see an inconsistency there. The TOR is for the internal operations of the commission, how they're going to conduct their work, and that is up to the commissioners to determine that. The lead counsel is there to assist the commission. But in terms of her appointment, the Attorney General appointed counsel, and if she was declaring conflict so that action will be taken to mitigate that conflict, she would come to the appointing authority, which was me in this case.
Now, the lead counsel had a team, didn't she?
I believe she was working with a team at the commission, yes.
And do you remember what that team composed of, or who that team composed of?
You know, like I said, you know, I had this approach at the time. We do the hard work. We find the right personnel. We set up these activities in the form of these commissions. It was like churning it out from a production line, a production machine. So when we set up, we gave them, you know, whatever support they needed. once they take off, we focus on the next commission because we had a line of commissions that we needed to set up. So I wasn't, in fact, if I tell you today, I'm sure many people will find this surprising. I have never watched a full episode on TV of any of these commissions, not even the TRRC, not one full episode. And that's because I just didn't have the luxury of time when I was in office to do that. It was always difficult. But
the team.
I know that we seconded one or two lawyers to assist her. I mean, had a team. I believe she also brought in a few lawyers from her chambers to assist her. But certainly there were one or two lawyers who were seconded to her team at the commission.
And those were lawyers from the ministry?
Indeed. Indeed.
What level were these lawyers at the time?
I can't remember now. But I had instituted a deliberate policy to second lawyers from the ministry to each of those commissions that were part of the transitional justice process. It was my way of also building the capacity of the ministry. I wasn't looking at the immediate processes. I was looking at how we could sustain these processes as a country so that when we build this capacity in the course of these commissions, that capacity will be at the ministry. And in the event that is needed in future, the ministry will not start looking outside. So I deliberately made sure that for the TRRC, the CRC, the National Human Rights Commission, the Banta Commission, the Janneh Commission, lawyers from the ministry were seconded as a way to build their capacity as well. I don't remember what level they were.
All right, you do not remember what level they were, but then you've made the submission that the commission was to be allowed to conduct its work independently.
Absolutely.
What stopped the commission from allowing other counsel to take over?
I don't understand what you mean. What stopped the commission from allowing who to take over?
Lead counsel came to you,
yes,
as soon as she realized that a conflict arose, right? What stopped that matter being dealt with as an internal commission matter, since they were independent?
Oh no, the appointment of counsel was by the Attorney General. So it was the Attorney General who could replace counsel. I could have chosen to replace her with one of the lawyers who was seconded from the ministry. But again, it goes back to my point. We wanted independence, complete independence. And that's why I went to seek another in the private counsel to step in.
Yeah, but Mr. Tambadou, it can't be independent when the 80% of the staff are in fact from the government. And perhaps I'm a bit loose with my stats here, but I would say 65% were from the MOJ.
Which staff? The administration?
Yes.
They were seconded. Yes. But they were seconded.
So where is the show of independence there?
No, but they were under the direction and authority of the commission. They were not taking their instructions from the ministry. Apart from it.
That's not the insinuation. My point is, your submission is that the commission was independent.
Yeah.
They could deal with internal issues as they please.
Yes.
Now, the issue of conflict, once commission has begun its work, is a matter for the commission to deal with.
Look, Counsel, I think you're mistaken. The issue of conflict is one that must be raised with the appointing authority, so that the appointing authority will take measures to mitigate the risk that that potential conflict could create. In this case, the Attorney General was the appointing authority of counsel. Counsel properly raised it with the Attorney General. Even if counsel, and I believe she would have raised it with the commissioners, it was by way of information only, because it was not the commissioners who were going to appoint another counsel.
Yes, but we're not speaking of appointment here.
But we're talking about replacing counsel. You replace counsel by another appointment.
Counsel was never sacked. was never removed as lead counsel. She remained lead counsel to the commission. I believe the conduct of certain proceedings was what was altered to substitute her for other counsel.
However you call it, whether it's by substitution or whichever way, there was another appointment. Even if it's temporary for a month or a week, it's still an appointment.
Yes, and I'm saying that since your submission is that the commission was independent, it could develop its own TOR and run and conduct its proceedings as it saw fit. What stopped the commission or the commissioners from, or even lead counsel from allowing other counsel to conduct the matter?
You want to know what stopped the commission from doing so? Maybe
Yes.
you should ask the commission what stopped them from doing so. But in my case, I think it was absolutely correct for lead counsel Bensouda to come to me and declare the potential conflict of interest, and for me to act on an interim basis to mitigate the risk that that potential conflict could create for the commission. And I did. And I appointed someone for a period. When the theme of Social Security was concluded, lead counsel resumed her activities on in respect of the other public state-owned enterprises.
Let me ask, who is responsible to decipher whether a conflict has arisen or not?
That's why I said right from the start that conflict is to be determined on a case-by-case basis. It depends on the circumstances. It depends on the parties that are involved in any particular arrangement. So there is no hard and fast rule here about conflict. It depends on the circumstances.
So in this circumstance, you stand by your testimony that lead counsel rightfully came to you instead of allowing it to be a matter for the commission.
But that's my point, counsel. The commission cannot appoint counsel. They do not have the power to appoint counsel.
But we're not talking about appointing counsel here.
But this is about appointing counsel to step.
No, it's not, Mr. Tambadou. With all due respect.
So what is it about?
Let's begin from the declaration. What is the appropriate forum to raise the conflict of interest?
Like I said, she could have raised it with the commissioners by way of information, but certainly to the appointing authority, which was the Attorney General in this case.
All right. Honorable Chair, I think we are at a deadlock.
No, we're not at a deadlock, counsel. Don't call it a deadlock. The thing is, I am telling you, you know, when you're making your declaration of conflict of interest, you make it to the hiring manager, the person who hires you, and that's normal in every system. And I am sharing my own personal experience with you, even given my current work, that when we have to make annual declarations of conflict, and we do it to the hiring manager. I don't want to be specific about that, and that's very normal. So
yes,
in this case, I was the hiring manager, and she declared her conflict to me.
That's understood. But here we are dealing with a unique body. You yourself characterize this as an independent body.
Yeah.
Now, that independent body should determine its own rules, its conduct. You've given it leeway to determine so much. Why can't it determine whether a conflict of interest situation has arisen?
Well, perhaps if there was a dispute about whether a conflict of interest has arisen or not, it would have dealt with it. But here, as far as I know, there was no dispute. Counsel declared the potential conflict and declared it to the hiring manager, which is in this case was the Attorney General, and
declared it to the government. I believe
you can say the government.
I would prefer to say the government, because the hiring manager would sort of denote that you are part of the commission.
Okay, but
so the government that was supposed to leave the commission as an independent body is who she reported to.
But it's the commission, but it's the government, if you want to use it's the government that appointed her in the first place.
Indeed.
So
And this wasn't a case where she was being removed.
No, she was being recused.
Yes.
Yes.
For 1 or 2 cases.
In
Now,
the case of Social
why
Security.
it had to be the Office of the Attorney General to deal with that instead of the Commission?
Because it
is
was
what
the,
I'm struggling.
because it was the Attorney General who appointed her.
But we're not talking about dismissal or appointing here. We're talking about a conflict of interest.
Yes.
I believe that conflict should be determined by the presiding officers.
And that's what I'm saying. If there was a dispute about the conflict, if there was a contention about the conflict, if there was one party who was alleging conflict and another party that was saying there was no conflict, then you expect the Commission to step in and adjudicate. But in this case, you have counsel who comes and declares that there could be conflict if she continued in that role insofar as one state-owned enterprise is concerned. I think that was very, very normal. There's no dispute about it.
All right. I would still insist, Honorable Chair, so to avoid the back and forth, I would say we're at a deadlock, and I would leave that issue to the committee to decide. However, I would still want us to focus on when the conflict arose and when it was declared. I am of the view that the conflict arose on the 12th day of July, 2017, when lead counsel was being appointed, because of her prior engagement, the same engagement that warranted her recusal once the commission had commenced. So I'm saying, I am putting it to you that this, the conflict arose on the 12th day of July, 2017. What would you have to say to that?
You see, my little knowledge about fact-finding processes is not to adopt an adversarial approach to it. It should be more of an inquisitorial approach, because there is no us and them here. This is about establishing the truth and the facts. And so it is in our collective interest to make sure that this committee is well informed of the facts from which to derive their own views subsequently. And I am saying that conflicts do arise in the course of our work, whether they are at the start or they are in the middle or at the end.
But the question is, when did it arise?
Some you can foresee, some occur unexpectedly. But it's the ability to mitigate the risk when they arise. I think that is what you're failing to grasp here, counsel. It's the ability to mitigate the risk that a potential conflict could create. And so, if, for example, I'll give you another example. If, for example, you are sitting in a recruitment panel and there are applicants for a job, and your wife is one of the applicants, and there are 100 more applicants. Because your wife is on the list of applicants, you can clearly see that this would amount to conflict. Are you going to recuse yourself right from the start from dealing with the other 99 applicants, or are you going to be involved in the recruitment process for the 99 applicants, and then when it's the turn of your wife, you recuse yourself as a result of the conflict? I'm trying to give an analogy here so you understand that just because you can foresee conflict doesn't mean...
I would indulge. I would indulge.
You see what I mean?
I'm trying to, but it's not quite the same.
But it is the same.
All right.
You have a situation of conflict. You're dealing with more people than your wife in this hiring exercise. You can see your wife is an applicant. Clearly, you can see there will be conflict if your wife's turn comes, but you don't get out of the hiring panel because of that. You sit in the hiring panel and you deal with the other applicants, and then when it's your wife's turn, then you recuse yourself.
All right.
So that's how you deal with conflict.
All right. To an extent, I agree. However, we're looking at the time that the conflict arose and how the two players dealt with it. Yes? And I'm sorry, but I have to drive this point home. That, let me take your analogy and indulge you. You see, if my wife was part of a recruitment, did you say the panel or part of the candidates?
She was an applicant, yes.
If she was a candidate. You see, unless my wife decided to fight with me that day, but I would know before I even entered the room.
No, I'm saying,
And
assuming
fact,
you know. Assuming you know.
Yes, I'm answering. Assuming I know, I would recuse myself from the process because not only
from the
would
start.
not only would I be,
Wow.
not only would I be conflicted with with my wife's session, but I would be prejudiced by other sessions because I would not treat my colleague's wife, if she comes into the room, my colleague's wife will not be treated fairly because I will have at the back of my mind that my wife's turn is impending. And the reason I say that scenario doesn't quite fit, I would amend that scenario a bit and say, if an authority asked me to select candidates amongst five candidates, and I know that one of the candidates is my wife, from the initial point where I'm being asked to select a candidate, I believe the prudent thing to do is to decline. Because not only can I not be trusted to preside over the session of my very beautiful wife, but I would be definitely biased if the other four come in the room.
I'm sure your wife is watching this. She will be happy.
Indeed. I intended that.
Okay. Look, counsel, people have different reactions to conflict. Some would take a more pragmatic approach, others would take a more idealist approach. Your example is quite idealist, and I applaud that. But if I were to make that decision, I would approach it in the way that Counsel Bensouda approached it, and not recuse myself from the entire process only because there is a potential conflict in one instance.
Very well. The reason why I would flip your statement the other way around to say that it is in fact declining that is pragmatic, and waiting for it to arise that is ideological. The reason I would state that is that this is a commission of inquiry. We're dealing with assets of an individual and their partners. Whether you like it or not, the evidence is intertwined. To sever the evidence is a messy affair. It's a cloudy affair. To say that I would wait until it arises when you are aware that it will inevitably arise. Now, I want to go back to your criteria. Your criteria was conflict of interest. That criteria was flawed from the beginning. You would agree with me. A conflict was impending, and that would have been the lead counsel would have had knowledge of that conflict from the 12th day of July 2017 when she received her appointment letter, along with the mandate of the commission, which is being referred to as the TOR. Correct? So let's make no mistake. Let's establish this. There was a conflict from that moment. That conflict was not declared. It robbed you of the ability to still offer the position to lead counsel.
What was the precise nature of that conflict, counsel? Wasn't it in respect of one state-owned enterprise? I'm not sure whether the evidence was linked in the way you said it. In fact, if you go through the Janneh Commission report, each state-owned enterprise was dealt with separately.
Of course.
I do not see the direct links. The only thing that links all of those state-owned enterprises is the former president who was fleecing our coffers of
Yes.
of our world. But otherwise, that's the only thing that links them.
All right,
Otherwise-
let me give you another link. Having read all the evidence before us, very tedious job, I can tell you that the accounts are invariably linked to the companies, just as they are linked to the properties, because you would need to withdraw money from public accounts. I believe that was the allegation levied on the former president. You take it from account A and invest it in an asset. Those two are invariably linked.
Yes,
you cannot separate the work of the commission
No, I'm
in
talking
that manner.
I'm talking about in respect of the different state-owned enterprise, because what you're telling me now, which is quite correct, is monies were being taken from different state-owned enterprises and being injected in private affairs, and I think that is clear. Nobody is disputing that, and I believe when the commission proceedings were on, the focus of the investigations, which is reflected, I believe, in the report of the commission, was that each state-owned enterprise was treated separately, and the transactions between the former president and those state-owned enterprises were separate. So I do not see how you would find difficulty in understanding why counsel cannot just recuse herself from proceedings in respect of one state-owned enterprise and then continue her work in respect of the others, because there was really no link between the different state-owned enterprises.
I understand that, and it is regular for counsel to raise that conflict. The point at which it is raised is the contention here. Now, at appointment stage, one of the criterion, and I'll give you two criteria. One of the criteria was conflict of interest. The question was posed, and the Ministry of Justice, or the Minister of Justice yourself, was not made aware from the 12th day of July 2017 of the fact that lead counsel is counsel for one of the institutions. And mind you, while it might be one institution, that institution owned about 3 properties that were in question and other assets such as vehicles, tractors, that are all the subject of the commission. And just another link, another criteria rather, is you had mentioned public perception, that the government wanted the public to gain the public's trust, and show the public that they were doing work. Now here is an issue arising from the person that is meant to conduct the case before the commission, or rather the issues before the commission, and there's a conflict that arose from the date of appointment. Now, that conflict, if it were made known to the Ministry of Justice on the 12th day of July 2017, are you telling me that you would have still acted in appointing lead counsel?
First, her response to me was very qualified. There is no particular reason why she cannot carry out the work that I was going to assign her. And 2, if there was going to be conflict, then appropriate action will be taken. And at the point where there was potential conflict, she did disclose that, and appropriate action was taken. I would like to believe that even if she had raised the issue of conflict with respect to Social Security and Housing Finance Corporation, I would have had the same agreement with her that when we get to that point, she can recuse herself and then someone else will step in until Social Security is covered. I think that is very, very usual, counsel, in the professional world. There's nothing unusual about it.
I still maintain, and perhaps another deadlock, Honorable Chair, I still maintain that the issue of conflict with the appointment of lead counsel arose on the 12th day of July 2017 because she had a prior engagement with one of the interested institutions that had several assets on its belt, and that engagement was made on the 7th day of June 2017. Now, with your permission, Honorable Chair, I would want to proceed to other issues. I would leave that issue to the committee once more. All right, I would move from it momentarily and refer to MOJ 3K, Honorable Chair. Secretariat, if you could guide the witness.
Yeah. Yes.
Yes. So MOJ 3K, I would, I think I've made you read enough, Mr. Bensouda, sorry, Mr. Tambadou. I would go on to fast track it and just read. MOJ 3K is a letter that emanates from Ami Bensouda and Co., Corporate Legal Services, and it's addressed to yourself, the Honorable Attorney General. Solicitor General is copied. This letter was issued on the 24th day of July 2017, and it is termed engagement letter. It has the scope of work. Now, perhaps I would allow you to read 1A and B for the committee.
You want me to read it aloud or just to?
Please read it aloud.
Aloud. Okay. Heading scope of work. The scope of the work which I have agreed to undertake is as follows. The management and administration of inquiry processes and procedures. To pay particular attention to the terms of reference and the applicable law, and to assist in ensuring that the Commission does not exceed its remit, i.e. its jurisdiction. And B, to assist in ensuring that there are appropriate procedures in place for 1. Document exhibit control and recording, 2. Identification and recording of assets before presentation to the commissioners, and 3. Analysis of financial banking records.
All right, thank you so much, Mr. Tambadou. I would give you some information. The committee is in receipt of evidence that since the government had allowed the commission to come up with its own modus operandi, the commission, or rather, yes, the commission opted to have a system where the lead counsel is privy to every single document that comes in to the commission. Were you aware of this?
I expect that to be the case in a professional environment, absolutely.
Now, I go back to the conflict. Issue arose on the 12th day of July 2017 when lead counsel was being appointed. She knew that there was an institution that would render her a conflicted party. Right? Let me land. Sorry. The practice in the commission was that every single piece of evidence needs to be brought before counsel. Now, counsel represents Social Security. Social Security will inevitably submit documents. Counsel will inevitably be in receipt of those documents. Now, if you go to B, 1B, it says, to assist in ensuring that there are appropriate procedures in place for document, exhibit control, recording. That process would mean that she would be au fait or privy to the extent of evidence that is available to the Commission. With that information in mind, do you still stand by your testimony that it was still proper to appoint her, or rather not to declare the interest from the 12th day of July?
I think it was proper for her to declare a potential conflict at the time that she did, before the Commission started its proceedings on Social Security and Housing Finance Corporation.
But was it proper that the interest was not declared on the date of appointment?
I think her response was qualified, and I wouldn't go as far as to say that the interest was not declared, but she had alluded to the fact that if an interest if an interest does arise or conflict does arise, she would avert my mind to it, which is what she did.
My point, Mr. Tambadou, is that a conflict did arise from the date of appointment, didn't it?
A conflict insofar as the Social Security is concerned.
Would you agree to that?
Insofar as the Social Security is concerned.
Of course.
Yes.
It was a conflict.
But whether it was a conflict before or after, the fact is she declared it and appropriate action was taken to mitigate.
Yes, but she declared it. She did not declare it on the 12th day of July 2017, the date of her appointment.
She might not have been as specific as she subsequently was, but her response to me was quite qualified.
Usually when...
Counsel, can you allow us to, we can take 10 minutes break for prayers, and you can resume back. Otherwise, we don't have quorum and members will have to pray as well.
Very well.
Please, huh?
Yes.
Yeah. Meeting adjourned for 10 minutes for prayer.